See, you're meant to be. You're meant to continue this.
Yes. Oh my God.
All right. It's all yours.
Okay. Well, welcome everybody. Happy Tuesday. This is That's What She Pled. This is Christina Goldberg. I'm here with Julie Lurson. Hi, Julie.
Hi, Christina, aka Christy. Are
AKA
we ready
Christy.
for a little fun and frivolity?
We're gonna try. We have to come up with some funny stuff because we do the heavy sometimes. We try to make it funny. But
I think we get a decent mix in. Today we should probably be able to tip the meter heavily towards fun and frivolous.
yeah,
I
we
mean,
do.
not frivolous.
Well,
You know how I hate that word,
I know
at
it's
least in
kind of a
conjunction
dangerous
with what we
word.
do,
It's
right?
true. It's kind of a dangerous word, but some of them really are. And that's where we, so Julie and I decided to talk about class action lawsuits, but more specifically, some silly class action lawsuits. But then we'll sort of top it off with some more, I don't know what word, valid, meaningful class
Yes.
action lawsuits. But
Yes.
even with those, some of them to discuss, okay, really, what does this mean? Like the overall payout was however many billion, but this is resulting in a check for $4.20 to each.
Right. Right. But and this also just sort of is a backdrop. You know, with tort reform, we've been accused of being frivolous and predatory, and
not us,
know,
all
billboard.
attorneys.
Well, injury attorneys, plaintiffs' attorneys, billboard attorneys. We happen to live in a judicial hellhole, Florida, and things like that. So, while that sort of obviously rankles, our feathers and whatever, it's not to say that there aren't some kind of frivolous lawsuits floating about. So,
right. It doesn't
in an
come
effort
from
to be
nowhere.
fair and balanced, right?
Yes.
We'll
We
shine
can
a
make fun
light
of ourselves.
on some of the sillier,
Right.
more frivolous lawsuits.
Exactly.
In our view, right?
Right.
Somebody thought this was worth pursuing.
Yeah, and it's so funny because we don't practice class action
No.
at all. So that's if anybody calls us and says, "Hey, do you know anything about Monsanto or any the
Monsanto Roundup?"
Yeah, the Roundup or the oh my gosh, I can't say it. The most recent, the military one, the Fort.
Oh, with the Camp Lejeune water.
Yeah, Camp Lejeune, all of that. We've had some calls and those go elsewhere. So we don't practice this, but just as sort of as a standard for what we do, one of the first questions, if somebody calls our office with a claim that we feel like, okay, and I mean, you're upset about this particular thing, but that's kind of our go-to is what are the damages? How does this really hurt you?
Primer, let's remind everybody, it's not just that somebody failed to live up to some duty of care they owed you. They were somehow careless and therefore, caused some harm that's a result of their carelessness. Then sometimes the ultimate question is what Christy was just posing, like, and were you hurt? Was anything, damaged? That's the fourth element. And that's, I mean, our system is based, our civil justice system basically gets people monetary rewards as the ultimate instrument to be sought. So,
yeah, and so it's and for a, I'll call us a small firm, although I don't know if we qualify anymore, but for a small firm, I mean, everybody has a business to run and pros and cons to taking on certain cases. And it does not mean that there is no case, but there are an awful lot of them that come to us that just are not, they're not, at the end of the day, we like our sleep. And it just doesn't feel right for us to become involved. And so some of these, as we were looking at these class actions that we'll go through a few of these, it's just the craziest thing to me. What attorney, oh, no offense to you, but what attorney is out there going, I got this. I'll take this on.
I need to right this wrong.
Right.
I need to right the wrong that it actually took you 4 minutes to make your Velveeta mac and cheese, not the 3 that was listed on the label, because, I mean, remember, we did have to tear the lid off the container of Velveeta mac and cheese.
You have to take
before
the
we put
packet
it into the
out.
microwave.
Wait, Julie, you have
I'm
to
sorry, did I
take
miss
the
a step?
flavoring of the cheddar packet out of, we're talking like these individual, so Kraft Heinz Company, these individual mac and cheese packets that you pop in the microwave for 93, well, this says 3.5 minutes. So a plaintiff got very, very angry and said, well, I have to tear the lid off. I have to remove the cheese packet. I have to
Sprinkle
add
it
the
about?
water.
Well, if you have to measure it, I'm sure.
Right. And then put it in the microwave. And then after, I then still have to stir the cheese packet and the water in. And so this 3.5 minutes, it's misleading.
We're 5 minutes into our day already.
Right.
And think of all those important things you could have done with that additional 90 seconds.
Oh my God. And an attorney took this on. Because and basically, and I had to dig into it just a little bit to go, okay, but wait, where's the damage? Okay, so it takes 5 instead of 3.5. Where's the damage? Well, the damage claimed is, well, I spent an exorbitant amount of money to have this pre-measured, pre-prepared, convenient cup of mac and cheese. And it's not, the convenience does not match the increase in price. Oh my God.
Okay.
Somebody took it on and made that a class action.
Well, I mean, asterisks, class actions, in my view, in my own experience, because I've certainly gotten class action solicitations in the mail saying that, you know, I may be entitled to some money, tend to compensate the victim in a very de minimis way, in my view. The attorneys, however, who can get a class action certified as a class action and pursue it to conclusion, often are well compensated in terms of their fees. So it is a business pursuit, pursuing class actions on behalf of Velveeta microwave mac and cheese victims.
And I'll just for a fun fact,
convenient,
extra for the 3.5 minute convenience. So fun fact, and this is from 2015, so it's dated, but it's kind of what I found. 2015 Consumer Financial Protection Bureau, a study that they did out of a sample of 562 cases, only 13% of those resolved class action lawsuits resulted in some type of actual benefit to the class members. 13% of those actually resulted in money going to the people. And then the same study found that the average award to consumers is $32, while plaintiffs' lawyers took home nearly $1 million on average.
It is a business to pursue class action lawsuits. It can be quite lucrative to the attorneys. Not so much for the little guy.
Right.
Yeah, we will not be taking any Velveeta cases.
No.
If you elected not to join the class and decided you wanted to just separately pursue your damages, thank you, but no thank you, as I sometimes say. To
more power to you. Right.
Yeah.
We're not saying you don't have a claim. Watch out for that statute of limitations. This has been approved by our attorney.
So another one that's kind of in that vein, I'm not sure what the resolution was, is someone who is suing over the amount or lack thereof of strawberries in their unfrosted strawberry Pop-Tarts made by Kellogg's. So
that was dismissed, Julie, just so that you know. It was dismissed. The court decided that
it was frivolous?
Well, yes, basically the court decided that that person had no reason to believe that there would be any specific amount of strawberry, or that there would not be other flavors in addition to strawberry. So I guess what they do is they use other filler fruits.
Apples, probably.
Apples, exactly. They use apples, and there was there was one other one, I forget what it was, but the court essentially said, you have no reasonable expectation. I mean, people, you're buying garbage.
Maybe it counts as one of their fruits for the day if they're trying to
Gosh.
get to 5 a day, whatever it is that is
I wonder if that does.
recommended.
Yeah.
So I had my strawberry Pop-Tart and it turned out it only had a quarter of a strawberry in it.
Right.
And I was counting it as one whole serving. Okay, we have bigger problems than
Far bigger problems with that.
strawberry Pop-Tarts.
Uh-huh. Yeah, that one I know was dismissed.
Okay.
Let's see what else we have.
Keep the faith, people.
So a man sued Texas Pete hot
Oh,
sauce.
love me some hot sauce.
Uh-huh.
Mhm.
But he sued because the hot sauce is made in North Carolina, not Texas. And the labeling and the imagery,
I'm shocked.
like the Texas Lone Star, the Texas flag, and the word Texas on the bottle, very, very misleading. And basically I dove just a little bit deeper into this because how does it hurt you that this is made in North Carolina and not
Well, if
Texas?
you're a Texan, you're
it's pride.
It's yeah, exactly.
It's
Let's
pride.
not mix and mingle with North Carolina.
That's exactly
Tar
it.
Heels.
That's exactly it. Yeah. And the product, and this is super interesting because the product actually does not ever say that it's
Made in Texas.
In Texas. In fact, it specifies that it is made in the main facility, which has been in North Carolina and expanded for decades.
Who's Pete anyway?
Pete is the son. Pete is he's a member of the family
of the creators,
the creators of this, exactly.
Of
Pete is a son, and Pete has a particular love for Texas
things
and spicy things, and yeah. But we sued because it's made in North Carolina and not Texas, and that was just offensive to the people who really wanted to feel like they were eating Texas. I can't.
Gosh, and I dug up all my receipts for the Texas Pete I've bought over the years, hoping that my ship had come in and I could retire.
This is so great. So great.
Darn it.
Onward. There are so many funny ones.
Oh, I liked the one about the guy who bought some eye drops, some allergy eye drops or something.
Uh-huh.
And he had determined that he really didn't get as much bang for his buck. And he apparently found that bottle only lasted for 20 days and when it should have lasted for at least 30. I think, now we're getting into how big is a drop kind of technicalities.
And I don't know about anybody else, but every single time I try to put eye drops in my eye, I miss the first time.
Yeah.
So, are we building in the extra misses here? I'm never going to get 30 days out of a bottle of eye drops if I'm trying to use them daily. It doesn't happen. Yeah. That's so good. I like the Altoids one though.
Oh, right.
This is it's the craziest thing to me. So cinnamon Altoids, I don't like them. I
love cinnamon Altoids.
They're spicy.
You probably don't like Texas Pete either then.
I probably don't.
Spicy.
I don't use hot. I can't like pepperoni.
You just pop a Altoid. Yep. Texas Pete for lunch.
No.
And then after pop a cinnamon Altoid
and then nobody wants to go near you.
What's the problem?
So with the cinnamon, you see them. I haven't looked. Now I have to look next time I'm at the store in the checkout line. Have they changed the design on it?
I don't think so. I think there might be a picture of like an actual piece of cinnamon. You know how it's like
cinnamon sticks.
A cinnamon stick, right?
Yeah, that's what it did. That's
because they have more than one flavor. So
correct. Well, the one in this lawsuit specifically was the one with the cinnamon sticks. I think maybe crossed or sitting across the tin. And plaintiffs joined in this class action and sued because there was no real cinnamon in the Altoids, and that they wouldn't have paid the premium that they paid for these cinnamon Altoids had they known that there was no real cinnamon. Well, on the front, on the top of the box, it says artificially flavored. On the back, it says made with artificial flavoring. It does not list cinnamon as an ingredient. But it's sitting there on the top of the box. But again, we would not have paid what we paid.
Cinnamon Red Hots, those little Valentine things that you
never had those either.
They're delicious. Or cinnamon fireballs. Do you suppose? I feel like there could be a subspecialty in terms of class actions where cinnamon flavored things are being misrepresented as containing cinnamon.
Right.
I don't know though. Did he prevail or she?
No,
Oh,
no, this
never
was
mind.
hi. It's
Forget that
written on
business
the
model.
top of the box. But these are the things that just make me go, as okay, attorney, you're
Right.
looking. There, there's no question here. There's no misleading. There's no consumer fraud. There's no, I don't understand it. Okay, that's fine. Win some, lose some. I guess when you stand to make $1 million, it's worth playing around a little bit. I don't know.
Right.
Well, because and a lot of these companies end up settling. I mean, there are some, and more we hear, for instance, you make a claim against it used to be Disney. I don't know what they do anymore, but if you make a claim against Disney, Disney will not settle. They will not settle because they were faced with so many claims for various things that people just kind of got used to, okay, I'll make a claim and they'll pay me some money. And so finally they decided we are not settling these
Nuisance
claims.
value.
Right. On the other hand, the because you get to a point where defense costs and
Yes.
depending on the state and the federal laws and all of that, how you can maneuver to try to get your fees
Right.
recouped, you may not be able to. And so a lot of times the defense costs are going to far exceed
Right.
what they could pay to just settle it. And so probably a lot of times these sort of quietly
Go
go
away.
away because they've
Or
been
some de minimis
solved.
nuisance
Mhm.
value because it's more,
Right.
it will be more costly to continue to litigate and defend than to
Right.
just pay and make it go away, close the door, and then the other person could be satisfied that
Yes.
they've righted this harm with society out there thinking that their cinnamon Altoids contain
Mhm.
real cinnamon.
Mhm. It's
I'll never think the same way again when I grab that tin of cinnamon Altoids at the checkout line.
you thought you were getting cinnamon.
Yeah. Yeah.
Yes.
What other silly ones?
Well, there's sort of the same thing, a lawsuit
Lots of
against
food.
Publix.
Oh, Publix.
These are, yeah, these are the funniest ones seem to be food, but there's one very similar to the Altoids one, lawsuit against Publix over their honey lemon cough drops. The lawsuit claims that the picture of the lemon cut in half on the front of the packaging makes consumers believe that the cough drops are made with real lemons. Again, neither the package nor the list of ingredients claims that to be true. I don't know the outcome of that one. I think that one's still pending, but I don't know. I mean, do you think people know that there are no rainbows in Lucky Charms? Or like when you open the box, is it supposed to
I
come
guess not everybody.
out of the box?
I'll never be able to walk down the aisles of Publix again without worrying about what they're misleading us about.
Well, it's so funny because this is the birthplace of, right? I can't think of one off the top of my head, but sometimes you see a commercial or something that at the very end of the commercial, there's this disclaimer, not real elephants or not real, like something that you watch and just go, for me, I mean, my eyes roll into the back of my head. Like, is that necessary? Yep, it is.
I mean, I'm getting a little. So, for instance, a lot of times on products, there are these warnings, and you're like, okay, what kind of idiot, please, really needs to be told to remove the windshield sun visor from their windshield before they start driving? But they'll be there.
Right.
Either
or some kind of toxic chemical. Do not ingest. Thank you.
This is right.
Yeah.
But I mean, is this because there have been frivolous lawsuits pursued, or is this just the attorney who's drafting the, protective language and trying to contemplate any and all
right? Is it proactive or reactive? Right.
Yes, exactly. So,
yeah.
Yeah,
and it's possible to be too proactive. It is possible.
Yes. But disclaimers, warnings, product warnings about intended use or not. So anyway, those give us the opportunity to chuckle and shake our head and wonder, and perhaps, concede that our opponents as plaintiffs' attorneys, such as we are, do have some valid points to some of their arguments. I'm sure, these provide great opportunities to capitalize on, to prove to the American public just how predatory and awful we really are. But there are certainly, in my view, plenty of good reasons for our existence.
Oh yeah. I mean, yeah, I get it. Overarching, you try to fix one problem, you end up hurting so many people trying to do it on the,
Right.
I don't know. I mean, there are a lot of groups that actually are continually, more federally, but continually trying to do away with this type of thing, these types of lawsuits. There was I should be more prepared. There's a landmark case fairly recently that basically ultimately, in order to have a class action lawsuit, you have to certify the class. So you
Yes.
actually have to go in front of a judge and get them to say, okay, there's a valid class here and there's
a commonality
injury
among all the potential victims and claimants. Yeah.
right. And you actually now, pursuant to this case that was within the past couple of years, you actually have to, as part of the certification process, you actually have to show, yes, indeed, there is an actionable, I'm not going to use the word injury, what
damage,
like yes, in order to have your class certified. So there are certainly entities trying to crack down on this. And this is not to say that all class actions are frivolous or silly. They are not.
Oh, no,
I mean,
no.
there are some major class actions, I mean, going on now or recently resolved that are 100% absolutely valid and necessary. Still sad. I mean, with a class action, it's so funny. Half the time I don't have any idea it's going on until I get some mailer or some email saying, well, you're a potential claimant in this Facebook class
3
action
years
or this
ago, you
whatever.
purchased this item at
this TV and
somewhere.
Here's this class action settlement. And you then have the option. Typically what it is you either have to opt in or you have to opt out. If you do nothing, you lose any claim to any class action money and you lose any opportunity to file your own claim.
Right.
So typically it's either opt in or opt out within a certain amount of time. There's almost always these days, there's a website that you can go to that is
where you
disclosed.
could upload all kinds of information to legitimately document that you are you are part of this class.
Right. And get information about dates and compliance and all of that. Yeah. Yeah. But typically you don't know about it until after it's happened, which in one sense is a great thing because you haven't felt the damage. Right. But if you are one of those people who has felt the damage and has sought an attorney's help with something, then you have, this is when a savvy attorney is going to say, let's make you the class member who turns this into a class action suit. Let's do it that way. Well, at that point, certainly one would hope that you're fully apprised and fully aware of the own issues that you're suffering and that you back yourself out of that and hire an attorney and go about it individually. I mean, there's going to be time constraints because class actions are handled, a lot of claims all in one. Yeah. So there's the benefit of let's move this through faster. On the other hand, for instance,
well, there's usually some kind of representative plaintiff who is sort of emblematic of the class as a whole, which is how they become a class.
Right. Someone is named.
And then, so long as you can demonstrate that you meet the qualifications, and you sit back and sort of wait for resolution. And then someday you get your check for $7.63.
Right. And that's kind of what happens. But so, I mean, going to kind of more serious ones, for instance, so there was a Charmin, the Fresh Mates, the flushable wipes. There was actually a class action for that. And this one I can see as being completely valid because they absolutely advertised as being safe for plumbing. Everybody now knows you cannot flush. That is not safe for your plumbing. The problem is this was filed in New York. New York consumers who purchased these flushable wipes thinking they would be safe for their plumbing. After
they had some plumbing woes.
After the class resolution, they could get up to $50. $50.
I'm not sure that even pays to have a a plumber show up at your house,
Like,
let alone roto-root your pipes.
exactly. So if you have to have something, I mean, God forbid you have just really major plumbing problems. So in this, I mean, great, I can understand. And okay, yes, I think that that's a pretty valid claim because they did. I mean, I recall they don't advertise that anymore, but the flushable thing, I mean, this is totally safe, flush. No, any plumber you talk to is going to tell you, oh, don't do that.
No.
But this is a class action that spanned, it was for like 9 years worth of purchases from 2011 to 2020. And it has since, it has since been resolved, but up to $50 per
Gosh,
person, unless
you
you've
bought
opted
those
out of it.
flushables for 9 years. I'm sure you had more than 50.
Can you imagine? Yeah. Yeah.
Yeah.
So
Let
that's
alone your pipes.
right. Things like that. So I see the benefit. I see the claim. I see the class action. But individually speaking, who did that help?
The attorneys and the plumbers.
The attorneys and the plumbers. Exactly. Yeah.
Okay, but I mean so there are definitely class action lawsuits that tend to involve well, I'm getting towards Roundup, but I'm also thinking of certain drugs and certain medical devices that really asbestos, all kinds of carcinogens and things like that that obviously have truly harmed people. With the Roundup, I think it was non-Hodgkin's lymphoma. So that users of that product, I mean, it definitely would kill the weeds, and also slowly, yeah. So, successful class action lawsuit back, I think it resolved just within the last couple of years.
2020.
2020. Okay. $10 billion settlement against Bayer, the manufacturer.
Yeah, but a portion of that was set aside to cover future lawsuits. I don't understand the specifics of that one, but yeah,
Think
of
about
that 10 billion.
how many
And I
years
don't
it
know
was
how
on
many
the
class
market.
Yeah, I don't know how many class members there were, but yeah. I mean, but then if you look at, so the $10 billion, that was for the class action. But then if you look at it, there have also been individuals who opted out of that class action, hired their own attorney and filed their own claims. For instance, California, a California jury delivered a $2 billion verdict to a couple, a husband and wife. So on its own, both of whom got this lymphoma. There was another California man awarded 80 million in a trial verdict. There was a 2018 verdict of 289 million to a groundskeeper who was diagnosed.
Oh yeah, landscape.
Yeah. So all of these individuals are nobody wants lymphoma. Nobody wants to have to go through it in the first place. You don't get it to go get the money, right? But all of these individuals are sort of helping themselves by opting out and making their own claims. In the meantime, $10 billion among, I should have looked up how many claimants, but this is a massive class action.
Yeah.
And I really am curious if there is any study or any information out there from someone who says that a class action benefits the victim.
Well, I guess I suppose to play devil's advocate, I mean, nobody's going to take just a onesie kind of case where there are legitimate damages, but they're quite small. I know I've certainly myself gotten quite a few about different investments that I've held over the years. And they, maybe there's some fee that I was charged or some disclosure that wasn't quite right. I mean, nobody's going to handle just one of those. So, you do have to get class action. And I suppose the benefit isn't necessarily so much that I got potentially could have gotten some de minimis amount of money out of it, but that it forced the investment companies or whatever to correct their mistakes. It also did line the pocket of the class action attorneys potentially.
Uh-huh.
Um,
Yeah.
I mean, it has the potential to cause behaviors to change. Um, think about some of those class action lawsuits involving a manufacturing defect in
Mhm.
which a company decides, you know what, it's, we could fix this. It wouldn't cost us very much money to make the fix, but in our, business analysis of it, we know that we're less likely that would cost us a lot more than it would cost us to defend a few lawsuits. So
Mhm.
maybe at some point it evolves into a class action, and therefore, you have now mandatory airbag replacements for cars that had Takata airbags for years and years and years.
Mhm.
Um, I'm not
It's
saying
true.
that
The more
that yeah,
equitable relief, the things that you can force the company to do. I mean, this is, auto
right.
manufacturers. I mean, time and time again, they know.
Yeah, and
They
and,
know.
and I don't know all the details, the predicate in the Takata lawsuit. So let me be clear. I'm not saying that they were necessarily motivated by money. I'm not saying that.
No, never. Nobody is.
I wouldn't say that
Mm-mm.
corporations are motivated by money.
No.
Corporations are people. They have feelings. Never mind.
Sure. Okay. We'll do that.
Anyway,
Okay. Uh, what else? This one I
well,
thought was interesting. Just kind of one more. The 1-800 contacts. This is an antitrust class
oh,
action.
mm-hmm.
Um, this one fascinating. So I don't wear contacts, but 1-800 contacts for I guess a very long time. When you Googled that you want to order your contacts online, it was 1-800 contacts that came up every time. No other options. Well, it turns out that 1-800 contacts had entered into agreements with other contact, I don't know, manufacturers or suppliers to negative out keywords so that when a Google search was done, they weren't going to show up. They had individual agreements with these other wholesalers, sellers, so that 1-800 contacts was the only company that would come up. And so they created a monopoly, which is a massive antitrust violation. Um, and so it's 1-800 contacts among with other these several other contact providers that actually were they paid a combined $40 million as
I
part of a
think they
class
strong
action.
armed them. So I actually footnote. I for various reasons have actually a fair amount of familiarity in the scheme of class action lawsuits with the 1-800 contact, and they were basically strong arming competitors to negative keyword out. And that's what got them into trouble under the antitrust laws. But actually,
Mhm.
ultimately, they've appealed and whatnot. And I'm pretty sure that the postscript really is that they determined that no, this wasn't actually in violation of the antitrust laws. Um, and it was I'm familiar with this because there was some sort of similar sorts of rumblings within, honestly, the personal injury bar about um, competitors
Mhm.
potentially, or at least theoretically, bidding on competitors'
Mhm.
names as part of their pay-per-click advertising campaign.
Mhm.
Um, and so,
We've been embroiled in it.
yeah, yeah. So anyway, but
Mhm.
class actions.
Interesting. Yeah, that part I didn't know, but I guess they did resolve
Hmm.
some of the claims. They agreed to settle 40 million, and individuals, this one was the highest amount I've seen. Individuals with receipts have been able to receive up to $800 because there are some people who've been buying them online for
Right,
life.
right.
And so if they can show their purchases about $800 a piece, that was a crazy high number to me. But yeah, and that's, boy, the Google thing and the negative keywords and the
Yeah,
bidding
that's
on
a whole nother
terms, and
podcast.
that is a whole other podcast. We've been embroiled. We've been accused of taking part in that, which absolutely 100,
Was wrong.
yeah, completely wrong. We have not. But I figure we'll be flattered by that.
Oh yeah, yeah. Somebody
We must be
feels
doing something
threatened
right to scare
by law
somebody
powered
else.
by women. So
Exactly. Exactly. So, I mean, that was a lot of sort of unnecessary and unimportant information, but kind of fun to talk about and fun to research and just get some overall understanding of um, what's happening out there and why there is such a bad opinion of
The
injury
plaintiff's
attorneys,
bar.
of plaintiffs' attorneys.
Some of
But
it's probably rightfully earned, but
yeah,
just like any group of people, it, a bad apple here or there can certainly kind of taint the whole bushel.
mm-hmm.
So we continue to fight the fight and
Yeah.
try to help people that we think have real negligence claims with real consequences to their lives.
Exactly.
And yeah, we'll keep at it. Sorry, Pop-Tart people.
I know.
Thank you, but no thank you.
Stop buying. Sorry. No, I
Mhm.
can't say that. That's not approved. Anyway. Buy healthy
Anyway,
food. So
this was fun. Hopefully
yes.
it was entertaining, a little bit insightful.
We
Now
try
you
to
know
be.
what to do with that mailer you get, inviting you to go through years of paperwork to prove that yes, in fact, you did buy some Pop-Tarts in 1973
Mm-hmm.
and you've never been the same since.
That's probably true for many reasons. Yes. All right. Well, that's that. So we'll
And
chat in a couple of weeks.
that's what we pled, or she pled.
That's what they pled now because
Mm.
we pled it. I don't know. So you can find us online, www.lawpoweredbywomen.com. You can see us on billboards, TV,
Yeah, we're billboard
restaurants,
attorneys.
movie theaters. We're everywhere.
Mm.
So we look forward to chatting. Anybody with any questions, don't hesitate to reach out. Otherwise, we will chat in a couple of weeks.